Ebisha for the brand and some hodo so ewe my Ghana ma say yen na ye nim eye sednam tamaklu. Mami we at temper with the public place and I say temper with Ghana for sika. Sika yen na Ghana for yen na ya de jasebi. Eda ho ye de bo Ghana ho bra no. Mami we de sebi ni sakaye e ma asemi e sha 2024 court Emma Mammy catch a judge or Snakunyam Sebi. The what don't know in officer on Quamman and in Uncle Jayarisha. Nana Hotona, she will come back in that trials. Akoso. Mammy put you more money every for any ethnic. Now we are, and I say in chair months ago, and a US embassy I will come at the HS. Mammy, I friend said in Tamaklu, a banaba intino. Meanwhile, not any information we are in free government or abase, and I say in free government or abase, mamma no ababiju. 80 a say from the US embassy or I work on Hashino. And then Fifi Quachi, a bishop for or the better about to see a mammy and friend said in Tamaklu, Ababi Pimu, or my Ghana. Now we shall for any assembly to already Ghana for in says sometimes a man no any ebidi, any ebisu edi. But no, people are calling Abronye Kwame this say Kwame Brabejo because it's summer of kind 2024 about this woman and then also the NDC party no. It seems any na ebe mu 1111 inti Kwame and I say Abronye DC Brabejo. It's a bebre na ekoso inti me pese message obren anyway bo na ayokoti ho ntem emrasia meda.
Say miscarriage of justice MIA and I'm so evidence via any record HSA Nipano ED4. So the court of appeal is faulted firstly by section 31.
It's your considered opinion, sir. When they establish a charge sheet very defective, no, what should have been the decision? Sir, they order a trial de novo, and answer.
I'm coming there.
Okay.
I'm coming there.
Okay, that's fine.
So the first time I say that's very defective, no. Next phase, and say, oh, she say, a dance here a warm crata, so no. A dance here is support to any other charge, you know, as you have it now. And I am pushing your catch them and not say, could work as a charge a defective one. What you do is say you order trial de novo.
In the end, she be asked for.
Exactly. Because Ebasana is on technical ground.
Yes.
So because we are talking about 90 million Ghana cedis. And I can't want them. But I would say, that sheet, you know, not defective. So that's the first point.
Okay.
Second point, now a dance here, court anymore, court to be any fast one, and a dance here one could be changing so I can say judgment, you know, Edimuana, make us say, Amen. Edi kind. 500,000 Ghana cedis, I can't say, Maslow for the Coma, that institution or Ashanti region, no. A dance here, the court, and they say, a Massa microfinance company in Sakan's the cano. Who say interest was no moon to be here. Don't miss some more the check. Ebra Maslow, my mate Temaklu, now send this class to be out for 3 years. My man can say, Debbie, on a board chairman, look at Debbie, with near cash. A dancing American to be a what dancing. Yes, I cash no bank, that institution is cano cash at the bar and kind. But you'll be sure, my man, there's a filling station, Barcelona, filling station. There are dancing,
okay.
And on this cano, a sharing. Then I'll choke that and a sackers cano. But the sackers cano, while found commerce lock accounts to be. It's a great dancing. Yeah, judgment and I can say, I still say a dance here anyhow. So that's the first a dance here. Solid. Unless say, could appear a patch and say, I can't dance there, my Jesus Christ. If I am a quarter any a dance here. Solid a dance here. Number 2, a dance here, I won't crack as well. She said, Mammy Tamaklu, and Mra, a shake and tamanto. Mahama Sammy 2013-2014. Because on my first time, Maslow for, na says cano, Umfankoma, get the 4 mano, and show me Omujum. That's kind of similar wrong at almost 1.4 million Ghana cedis. Audits now, yeah, the kids, it shows say, kind of the core man or no, close to 700 plus thousand Ghana cedis. Almost 600,000 or 700,000 there. Can anchor money be out. And we are dancing report at the court farm or so. Number 3, Maslow, say, sensitization program from a manner, from about 80,000 of them throughout the 10 regions, 10 regions organizing. And on budget close to 1.8 million Ghana cedis. Mami Tamaklu, Eco Region, and Sape, out of the 10. Yes, so called yes, score spending a pay within 1,300, meaning I maybe 13,000. 1,003. So meaning almost 1.7 plus a million Ghana cedis, and also of fire. Another one. We are financially literacy for our clients, maybe. Don't buy 246,000 Ghana cedis. 1 year when you can spend even 1 cedi out of the amount. 1 year program na nipani let's can pass and go back. Do here dance we a war in Kratemu. And the last one. We saw more talk has be 350. Yeah, the dance by the Kana Canebo in a costo pano a $10.something million. Now so we have $14.5 million. Yeah, a dance any Sunday my ina a womb. Now the same a mama cranny say. I dance at the bay more good no, mamma no United say on my court, I mean and say I deal with it and you know correct in it here. So on what basis would the court of a PC say a dance here in this assembly with me? A year I'm making also opinion that can so when you know correct, Mr. Scanner by the coha, the winning coha, then that is all two sides. Minister criminal prosecution, the state must do approve his case beyond reasonable doubt. But on the side of the prosecution, I mean, I can tell you without any equivocation, the state prosecutors tells me the man we the public servants investigators the kind of auditors don't be a dance or court. The other court to Ghana like court of because a dance anywhere. Like I say, idea,
but lawyer, even before whether the charge sheet was defective and also defective, no, on even the evidence, no, and the probative value according to evidence, no, the Court of Appeal in Omu conclusion page 92, 93, and 94. Mintimin kind, and I'm only taking a cursory look. So I may share conclusion almost say. Paragraph 120. It has long been the golden thread running through our criminal jurisprudence that the prosecution must prove the guilt of the accused and that this burden never shifts unless the enabling statute or law has expressly and clearly said otherwise. The principle articulated by Viscount Stanky in Wilmington versus DPP, our law student, and unshaken since is not a technical nicety of procedure. It is the constitutional expression of the presumption of innocence, and it is owed to every accused. 121, I'm going to say, the learned trial judge lost sight of this. Confronted with a charge sheet drawn mostly in negative terms, that the appellant had acted without authorization or without due process, she reasoned that because the prosecution had averred a negative, it fell to the appellant to prove the positive. That authorization, process, or justification in fact existed. With respect, that reasoning inverts the very principle it purports to apply. 122. The manner in which a prosecutor chooses to draft a particular offense cannot, of itself, relocate the burden of proving an ingredient of the crime. A negative averment, artfully or carelessly pleaded, is not an exception or proviso. It's not an exception, a proviso, or a statutory defense. It remains in substance an element the prosecution must establish, and the difficulty of proving a negative is the prosecution's difficulty to bear, not the accused to solve. I will go further to emphasize the principle that unless a statute plainly places the burden of proving a particular element of an offense upon the accused, she is under no obligation whatsoever to lead evidence in aid of a prosecution's case that has not yet reached the threshold the law demands of it. To require otherwise is to ask the accused to complete the prosecution's unfinished work and to convict her for declining the invitation as was done by the learned trial judge. The prosecution's evidence on a fair and unaided reading fell short of proof beyond reasonable doubt. The shortfall was not made good by any burden properly resting on the appellant, and the trial judge's misdirection on this fundamental point goes to the very root of a fair trial. For these reasons, therefore, I am satisfied that the conviction and sentencing on all the charges, including those manifestly defective charges, cannot stand. I would allow the appeal and set aside the appellant's conviction and sentencing on all count. In the way and Justice Emmanuel Ankama, I'm not sure this lead opinion, the conclusion, one, the evidence he believes say you couldn't prove the case beyond reasonable doubt because that it was for you to prove and not for the appellant, to rather prove positive. When you crafted the charge sheet in the negative. Okay, counsel.
The judge misapprehended, misunderstood the import of the prosecution's case. With a great respect to the judge, his appreciation of the burden of proof